All right, everybody. Well, welcome to the second to last module on, excuse me, on estate planning. I am actually going to just do this from the PowerPoint, so I'm not going to be drawing on the screen just to hopefully minimize, confusion. I just kind of want to provide, again, a high-level overview as to what estate planning is. And again, this is a topic for many students. So I guess you're just starting out in your life. You're not really thinking about distribution of assets. But again, for those that are interested in this type of career, this is a very interesting topic because you are kind of like acting like a Rubik's Cube solver. You're trying to put all the right pieces in the right places. And sometimes, depending on the assets that a client might have, they might have small businesses, they might have significant investable assets, they may have property. They obviously could have personal property. It can get very complex. They could have assets in multiple states. So anyways, it can be an exciting opportunity to help those clients really think through the distribution of their estate. But this lecture really is just about providing you some high level overview as to what you need to be thinking about and what goes into kind of this idea of estate planning. Okay, so basically, estate planning is nothing more than a plan for how assets are going to be distributed to heirs at your death. That's pretty much all it is. Now, what's part of this process is it's not just I die and then I'll let the pieces fall where they may. It's a proactive approach to managing these assets while you're still alive. Okay, so there are a wide variety of tools, and I call them tools. They're really more documents that are used within the estate planning process. And you'll notice down here in the bottom of the screen, there are things such as a will. That's probably one of the most basic forms of estate planning tools. A trust. There's also things like powers of attorney and living wills. And then there's also ways that you can title certain accounts. So, for example, you may have an account at your local bank where it's just your name. Well, you could actually add someone else to the account, and it could be a joint account. And that actually has estate planning characteristics to it. Okay, so again, how you tax or how you label accounts can be part of this process. All right. Every year there is, and this might get a little complicated, so I'm going to try to keep it very simple. The US government allows you to have a certain amount of assets that are not going to be counted toward the estate tax. Okay. And in 2024, that amount is $13.61 million. And as a couple, if there's a married couple, they would actually get up to 27 something million dollars. Okay. But each individual has $13.61 million of assets that are automatically exempt from estate tax. Okay. So basically means if you own assets that are going to fall less than $13.61 million, your estate tax will be it'll apply, but then you get a credit that will offset that amount. So in essence, it's basically you don't pay tax on that amount. Anything over that amount is going to be taxed at a rate of 40%. So that is, as of right now, the tax on values greater than that 13.61 million. Now that's important. Let's say you are a business owner, and let's say your business is worth $100 million, and you are able to remove 13.61 million, and let's say you die, and now you have to try to understand how to try to reduce paying 40% on an asset of $87 million, right? 40%, almost 50%. So you're looking at, $35 million in taxes to the US government. So we want to try to help clients through that process. Here's just a little bit of a chart that shows you kind of like how estate taxes have changed over the years. So you can see that in 2001, the exclusion was $675,000, and anything over that amount was taxed at 55%. And as you see here, the exclusion has continued to rise, and we stopped this at 2018, in which the exemption amount was 11.1 million, and that the value over that amount would be taxed at 40%. So we've ranged from 55, and then we kind of snuck down before 50s down to 45, and then it went down to 35, and then it's kind of remained at this 40% for the last, roughly 10 years or so. Estate taxes is going to be based on how much your estate is at death. However, there is also a separate tax system that is regarding gift taxes. Again, I don't want to get too into the weeds, but basically, you can give up to $18,000 in 2024 per beneficiary, meaning per person that you're giving the money to, and that does not apply to any gift tax returns that you would have to be accountable for. So that exemption amount is actually combining both your estate and your gift taxes. Okay. So you don't actually get an estate exemption and a gift tax exemption. It all falls under this total lifetime tax exempt limit. Okay. And again, let's not get into too much detail. All right. What can gifts help you do? Well, obviously, if you're gifting assets out of your estate, then those estates will not be distributed and may or may not have to go through or would not go through probate. And probate is the process by which assets are distributed to their heirs through the court system. Okay, so that's what probate is. If someone dies and they have a will, then they will go to court, or the executor will go to court, and they will then present all of the assets to and the will to or the will, I should say, to the judge. The judge will say, okay, yes, now you can go ahead and start to distribute assets according to the will. However, because it's a public hearing, people can start to challenge the will, and again, that can create a lot of mess. There are opportunities, however, that individuals can give an unlimited amount of assets to certain individuals or entities and would not be applied to the total exempt amount of 13.61 million. You can give everything that you have to your spouse, and there would not be a gift tax applied to that amount. You can give an unlimited amount to charities. You can give an unlimited amount to political organizations. You can pay educational expenses. And as you see on the slide here, you must pay that directly to an institution. So let's say you have a grandparent and they have, let's say, a lot of money. They can actually write a check to your university, in this case, Kansas State, and they can not account that toward a gift. Okay. They can also pay medical expenses directly to any medical service provider, again, directly. They can write the check to the hospital, and those would not go against the gift tax exclusion. And you can do as much of that as you want. Okay, so how do we calculate estate taxes? And remember, this idea of estate is how much is left from someone who has passed away. Okay, so the first thing we want to do is we want to calculate the gross estate. We want to include all the assets that are owned at the time of death. Okay, and calculate your taxable estate by subtracting out funeral expenses, debts, taxes, and any other allowable deductions from what you just found in step one. So you're going to gather up what was in their bank account, what's the value of all their property in their home, what about life insurance, what about investable assets, what about cars and homes and property, all of those things. You're going to take that value and you're going to subtract out expenses for the funeral, expenses to cover the estate, pay off any debts that are owed, pay any taxes that are owed. And what's left is the adjusted estate. And then you get to take into account any taxable gifts that were made during the lifetime. And then finally, you will have that amount is going to then be applied to the current tax rate to determine what your liability is. So again, determine the gross estate, subtract out allowable deductions, calculate the taxable estate, apply the current estate tax rate, which again is 40%, and then you subtract out any available credits. And that credit is the equivalent amount of a 13.61 million asset base. Okay. When you're thinking about estate planning, one of the things that we need to be aware of is how are we going to name the individual who is going to receive the assets? We call that the beneficiary. So we want to designate who is going to receive assets when we pass away. And we want to make sure that the different types of accounts that we might have or the different assets that we might have are labeled properly. Okay. So we can use PODs, which stands for payable on death, and TODs, transfer on death. And really the difference is the type of account. Most banks use payable on death. A lot of investment accounts use transfer on death. It really is the same thing. Okay, so as I mentioned previously, one of the most common and useful tools in the estate planning process is a will. A will is nothing more than a document that one outlines who is going to serve as the administrator of the will, the executor or executrix. That is the person who is going to make sure that the will is distributed according to the will's wishes. And then it's going to make sure that it identifies the assets that the individual owns and where those assets should be transferred upon their death. Okay, so those are kind of the three main aspects of what a will is going to do for you. All right, so how do we create a will? Well, first, you must be of legal age, 18 years of old, 18 years of age or older, and you must be of mental competence. And that's important because there's a lot of people who will argue a will's distribution requests that the decedent, the person who died, was not mentally competent in order to distribute the assets. And a lot of times that occurs because people who fight wills are those that are not receiving what they expected to receive. All right. Another thing that must occur is you must be free from any undue influence. Basically, you cannot be pressured or blackmailed in any type of uh, distribution request being applied to your will. All right. Formal requirements. A valid will must be signed and dated. And there are a couple of other options if people are unable to do that. In most cases, it needs to be witnessed, and in some cases, it needs to actually be notarized. Okay, um, and there are current companies out there. LegalZoom is probably a very common one in which you can create a will online. But in many cases, you might want to go and talk to an estate planning attorney to help you draft a document. Okay, a will that's going to align to your specific needs and circumstances. Okay, the executor or the executrix is the individual who is responsible for carrying out the wishes of the will. Okay, they are primarily responsible for making sure that all of the assets are put into some sort of consolidation account, and then, of course, distribute those assets once that occurs. We could also have a guardian in a will. Some individuals may die before any of their children or people that they're responsible for are of age to be able to take care of themselves. And so you would want to make sure that in a will you have guardianship provisions if you have children or expect to have children before any type of update. And of course, we all don't know when we're going to die. And so it's important that this be done. If not, children then become wards of the state, and that's not normally what we want to happen. Okay, so let's say you created a will, things are going well, and let's say you have another baby or something like that occurs, and you need to change your will. A codicil is a document that specifies changes in an existing will. So it is a legal instrument that is attached to a previously executed will without creating an entire need to rewrite it. So in other words, you have a will, and then the codicil would actually be written so that it says, as of this date, there is now a new beneficiary that is going to be placed, and here are the different beneficiaries that are now going to be outlined. Okay, and that would be attached to the existing will. So you have an existing will and a codicil. And again, this can be used for typically small changes, right? If there's going to be a massive change of distribution, that might actually be something in which you would want to rewrite the entire will. All right. Again, wills are a document that must go in front of the court. And this actually is problematic for some people. There may be people who don't want their assets to be known to everybody, and so the probate process is something that is taken in front of the court. There is an open hearing on that, and the individual's wishes then are outlined through the court process. Okay. Now, if you die intestate, which is the third bullet point on this slide, that means that you die without a will. And then all of the assets then go to the court, and the court has to make the decision on how those assets are going to be distributed. Ideally, we don't want the court system distributing our assets. Okay. So in the best possible way, we want to make sure we're having conversations with ourselves and anybody that we're helping regarding it's very important that we establish a will. Now, there is also things such as letters of last instruction or side instructions or side letters. They're kind of all named differently. But this is really just a letter that's written so that individuals can help to identify the wishes of the decedent. Okay. It can be written to a surviving spouse. It doesn't have to be. But it is something that is not legally binding. Okay. It's not a document that's been notarized. It's not something that typically is drafted by an attorney. So it is not a legal binding, but it does help provide instructions. Okay. Now, how do we then think about all of the things that go into this idea of estate planning? Well, what we have to do is we have to start to gather documents if we're the executor on what that individual had access to or owned during their lifetime. So things that they might be able to start to get their hands on, things like life insurance policies, retirement accounts, any other bank or investment accounts. It's probably also good to find their most recent tax return. You want to look for things like their deed or their homeownership and mortgage information and any other information related to other assets. Do they already have perhaps they have a trust? Do they have legal documents? Or are those the most recent legal documents? Do they own businesses? What kind of debt do they have? Personal loans, business loans, credit card informations, those types of things. These are just a few samples of things that an executor would want to get their hands on to help to start compile the information and the assets in a way that then can be easily distributed to the heirs. Okay. Now, let's say you've had a trust and you start to realize that maybe you're starting to get maybe some more assets and you want a little bit more control over its distribution. And more specifically, you don't necessarily want the assets that to go in front of the court. You can actually develop and create a trust. A trust is a legal entity that holds and manages assets for an individual. Okay. And what is very neat about trust is that they're very flexible. And you, as the grantor, the person establishing the trust, can make changes to the trust as you see fit. Okay. And again, what's nice about a trust is it by default, it has beneficiaries in the trust that will be responsible or receive the assets from the trust, and it does not go through the probate process. So there are a lot of people that will like to have a trust so that it doesn't have to go through the court system. Okay, so what are some benefits of a trust? I mentioned a few of these earlier. One is it creates privacy and it can create protection because it's its own legal entity. So trust assets avoid public probate. Okay, and it is very challenging to fight in court. Okay, so it does provide some protection against the assets. It also again provides flexibility. It allows the trust to change the asset distribution whenever they would like, and it can create some estate planning strategies for things like freezing assets, etc. Okay, and there's a lot of different ways that trust can be used. So it can be used to hold assets. It can be used to distribute, hold assets that are going to distribute income to the beneficiaries. And in those cases, we look at things like special needs. There may be a child that is being taken care of that has special needs. maybe they're disabled, maybe they have any type of disability, and a trust can be established that's going to provide a stream of income for the care of that child. Let's say you have a trust that's established for just the beneficial owner of a child, not even necessarily they're disabled, but let's say they're 10 years old. We probably don't want to give a significant amount of assets to a 10-year-old. A trust can actually manage those assets and pay for the support of that 10-year-old. So with that being said, we have to keep in mind that trusts are more expensive and they do create some time for those trusts to provide all the benefits that are needed. Think about an estate. An estate will provide the distributions to the estate uh, in basically lump sums. Well, a trust could pay out lifetime income for this child of 10 for the next, say, 50 years, right? That would be a drastically longer period of time than a one time distribution. All right. There are many different types of trusts, but one of the most common is what's referred to as a living trust. And we could also refer to this as a revocable trust. Okay. A revocable trust is a trust that's established by the grantor with the ability to make changes. In other words, they still have the ability to control the assets when they are in trust. They can add assets to the trust, they can remove the assets from the trust. They have complete control. Now, there are some advantages and disadvantages of having a revocable trust. Okay, so as you see here, the advantages they allow for the avoidance of probate. They can save some time and money depending on what you're trying to accomplish. It can provide privacy, and it allows the flexibility to make changes during the lifetime of the grantor. Keep in mind, the grantor is the individual that establishes the trust. And let me just pause here for a moment. The grantor establishes the trust. The trust is managed by the trustee. That's the title of the person who manages the trust. And those two people can be the same people. They don't have to be. Then there's also the beneficiary of a trust, and that's the person who is going to be receiving the benefits of the trust. So there are three main parties to a trust. There's the grantor, the one who establishes the trust, the trustee, the individual that manages the trust, and then the beneficiary, which is the one that receives the benefits of the trust. Now, there are some drawbacks to living revocable trust. Again, they're going to be more expensive to set up than just a basic will. They do not provide protection from creditors or estate taxes. And the reason that is because the grantor still controls those assets as if they were in their own name. Furthermore, they require ongoing management. So there has to be a trustee that is managing the assets. So just because an individual puts assets into a trust, they still have to be managed, and in some cases, depending on the function of the trust, may require distributions to be made, which can take up time. On the other hand, there are trusts that are called irrevocable, and basically an irrevocable trust is once an irrevocable trust is funded, the assets are no longer part of that individual. They cannot remove the assets from the irrevocable trust. They are gone, okay, from the ownership that they had with the individual. What benefit though is they do not have to include those assets within their estate. Those assets have been removed from their estate. So some disadvantages and advantages of irrevocable trusts. It can reduce estate taxes because, again, these assets are outside of the estate. It can protect assets from creditors. It can provide privacy for asset distribution. And it can help ensure specific assets to be managed in the way of the grantor. The disadvantages is once that decision is made and the assets are placed in an irrevocable trust, it can no longer be changed. It is irrevocable. And with that, you lose control over being able to do with those assets what you would like. Now, there can be some complexity in setting these up, and there's some potential tax consequences. Again, you are giving assets away, so you need to be mindful of how those are going to impact your tax liability. Okay, So we've talked about revocable trusts that are established by an individual and they can be changed. We've discussed irrevocable trusts, trusts that are established by an individual but that cannot be changed. And now we're just going to take a quick focus on testamentary trusts. These are trusts that are established upon the death of the individual. So let's say that I have in a will, I create a will, and in my will, I'm going to have a trust created. So when I die, the trust like snaps into existence and it becomes effective at the date of my death. A couple of other things to be mindful of are things like power of attorney. A power of attorney basically means that I, as the principal, will give someone else the authority to act on my behalf. And in many cases, this is used for financial transactions. Just to give you an example, when my wife and I moved from Texas up to Indiana, I was unable to come to Indiana when we were going to close on the house that we were buying. So my wife came up to Indiana to sign all the papers, and I gave her the power of attorney to sign all of the documents for me on my behalf because I wasn't going to be there. So she signed all the documents for her. And then I had a form sent with her that said, I, Justin Henniger, have provided my wife, and I'm just ballparking the language here, a limited power of attorney to act on my behalf during this real estate transaction. Okay. And it was notarized. And then that gave her the power to sign on my behalf. Okay. Now, this can be very helpful in that there may be things like, let's say you're going to go out of the country and there may be a transaction that has to occur. Or maybe someone becomes disabled, okay, and they're incapacitated. They may not be able to act on their own behalf. So that's when power of attorneys can be very powerful or useful. There is also this focus on a healthcare power of attorney, and it really is basically telling the medical profession who can make healthcare decisions on your behalf. So let's say that you were in surgery and some reason you just didn't quite wake up for you didn't wake up. A healthcare power of attorney should be provided to the healthcare that says, I can provide the decisions and make the decisions for that individual who is unconscious or in a coma or whatever. I can make decisions for them. I have a legal authority to act on their behalf for their health care decisions. In other words, should we provide them this medication? Should we move them to a new facility? Whatever the case may be. Okay. Now, that is different. A healthcare directive is different. I'm sorry. A healthcare power of attorney is different than a living will. A living will is basically outlining, will life continuing treatments be needed? The individual who has a living will has been given the authority to make a decision regarding one person's life if they are unable to make that on their own. The best example is if someone is in an accident and let's say they're in a coma and they're on life support. The decision will need to be made as to whether or not life support should be continued. The living will give an individual the right to make that choice on behalf of the person who is in a coma. Okay, so obviously that is a very, very important decision to be made regarding not only the individual, but the person who they've given that directive to, and to ensure that that person knows their wishes. There are some people who will say, absolutely, keep me alive. There is hope that I might come back from a coma. And other people say, if I never want to be on a ventilator. I never want to be, a vegetable. Please pull the plug and let me go. Okay. So there's those decisions, and that's made through a living will. A place that you might go for legal assistance regarding this is NOLO. Okay. And you can look at wills, trusts, and probate. And there's some articles there that you might take a look at. All right. So again, just kind of a rundown here. Estate planning is not normally just about you, obviously you being the one that has deceased or that is deceased, but it's about how you're going to help their loved ones and help them through the asset distribution. And when we talk about estate planning, really there's some things that we want to make sure that are there, right? We want to make sure that assets have proper beneficiary designations, A will, if we can do that, a will would be the first step. Power of attorneys, both financial and healthcare, and if possible, we want to try to have a living will or a healthcare directive. Okay, um, just a quick kind of a question. A legal document specifying distribution of your assets upon death is a C. Will. That is a legal document specifying distribution of your assets upon death. A trust may have distributions, but they may not. Okay, so it doesn't always necessarily mean a trust is going to distribute at death. Which of the following is not necessary for a will to be valid? All heirs must agree to the terms of the will. That is not necessary. They do not have to agree with the terms of the will. Does the will need to be dated? Yes. Does the will need to be signed? Yes. Does the person creating the will must be mentally competent at the time the will is written? Yes. So the answer here is A. In estate planning, it's crucial to understand the key terms and roles involved. One such important term is beneficiary. The person specified in a will to receive part of the estate is called that's right, beneficiary. Who is the grantor? The grantor is the individual who is establishing a trust. Who is a trustee? That is the individual or entity that's responsible for managing the trust. Excuse me. An administrator is typically going to be someone who is assigned by the court if someone dies intestate. All right, what about the duties of an executor? Which of the following is not a duty of the executor of an estate? Collect money owed the estate. Yeah, they probably wouldn't want to do that. Decide how the assets will be distributed. No, that's the responsibility of the decedent in their will. Do they pay debts of the estate? Yes, the executor would do that. Do they sell specific assets? Yes, they would do that in order to make sure distributions are occurring. If you wish to be cremated when you die, where should this request be included? A simple will. Okay, a will doesn't have anything to do with how the person is how their body is taken care of after their death. Okay, what about a letter of last instruction? Yes, these are going to be instructions, again, in many cases assigned to a spouse or perhaps the person who is going to be taking care of the will. Just, hey, here are some things I would like. Okay, what about a codicil? Remember, a codicil is a change of a small feature of the will. And probate, of course, is the court process by which a will go. So in this case, it's the letter of last instruction. A codicil is a document that specifies changes in an existing will. Okay, so the quiz presents the following options. I'm not sure what this question is about, but the answer obviously would be a codicil. It's a proper legal document used to make changes, or I'm not sure what what I was thinking when this slide was created. Forgive me. Okay, which of the following is commonly chosen as an executor? An attorney, could be a family member, could be a bank or a trust company employee. It could be, in this case, it could be all of those, okay? Or any one of those, not all of them at the same time. All right. Which legal document involves one person transferring assets to another who manages them for designated beneficiaries? Remember, we have a legal document in which an individual transfer assets to a trustee who manages the assets. In this case, it would be a trust. All right, last one. Blank trust is one that cannot be changed. Right. It's an irrevocable trust. Remember, a revocable living trust is a trust that can be revoked. It can be changed by the grantor. A spendthrift is really nothing more than the idea that you're going to set parameters on how distributions of a trust will occur to help eliminate people just splurging and spending money irresponsibly. Retirement, of course, is just the act of retiring from your job. So in this case, the answer is C, irrevocable. All right, well, that wraps up this concepts of estate planning. We have one more that we'll get to, which is going to be money behaviors. hopefully that'll be wrapping up and you'll be excited to get through that. So I will see you shortly.